Thank you very much, Emmanuel. Alors, now it's time for debate. We have 20 minutes in front of us. Is there any question in comments or you would like to address? I'm taking, maybe what I do is I take all comments and questions, and then we have again a round where you pick up the questions and what you want to answer.
Thank you. Thank you to all of you. There is one thought that's lingering in my mind is, in light of all this great thinking and bright minds, not only of yours, but obviously a lot of other people thinking about the same thing, what do these efforts look like in light of the revelations of the recent Snowden affair and its ripples, also the realization that just about every other country is doing the same thing, and some other thing, which is, for instance, the fact that a lot of countries are very interested and ready to take up China's models to telecommunication or communications monitoring and management.
Merci. Je prends toutes les questions. I take all questions, and so please write down the questions.
Hello, thank you for your interventions. My question is to know where is the role of the citizen or end user in global privacy governance, especially when privacy by design is to be a key mitigation tool regarding to big data issues. Thank you. Sorry. So, where is the role of the citizen of end user in global privacy governance, and especially when privacy by design is to be a key mitigation tool regarding to big data issues?
Hello. My question is the following: is it possible to organize governance in a flexible and agile way so that it doesn't come after the battle?
D'autres other questions? Myself, I had a question which really relates to the last sentence of Pierre-Emmanuel, is that with your presentation from the legal point of view, we have the impression that we are in an ideal world, that, you know, we are reaching conversions, that, you know, interdependence is moving, that we are reaching a minimal standard, that everything goes relatively smoothly, that it takes time, but, you know, we are managing to get our way around. And when you look from the, you know, citizen point of view or business point of view, the temporalities seems to be rather different, you know. So my question is, of course, it's a kind of philosophical question, is how can legal process, governance, integrate the different level of temporalities, you know. Voilà. So who commence par qui? Florence, vous risquez,
Thank you. I'm not sure I will answer to all the questions, but on the first one, the Snowden case, we have been very much involved at the CNIL level on this, on the Prism, on the Prism file. We just to tell you a bit about what we did. We created a working group at the CNIL, and we conducted some hearings with some companies, but also law firm and also public institution about Prism. And we also are working at Working Party 29 level. There should be an opinion that will be adopted, we hope, in December about Prism, in order to give our point of view on from okay. Yeah, it's better. On this issue that is, of course, very sensitive, very difficult, because it's about secret services. So it's a very touchy issue. The problem right now with Prism is that we have a lack of information. I mean, it's very hard to know exactly the facts, and in order to, I mean, to have an opinion and to have a thorough and solid legal analysis, and also to get some conclusion, you need first the facts. So it's not again an easy things to do. There has been some kind of working group created by the European Commission with the US, where we have our the president of the working party that is participating to those very close meetings, and so there are a lot of things going on about Prism in Europe. Also, the European Parliament conducted some hearings, and our president, Mrs. Falk-Pirotin, was heard. I think it was last week by the European the Euro deputies on Prism. So it's we hope to have something to publish in December. For the moment, what we are doing is that we are really trying to conduct analysis on the transfer issue. So because you can have different type of scenario where if in fact was a direct access in Europe, or whether it was transfer of data and then access in the US, and the rules are not the same from a privacy point of view. So that's something that we are doing. So I don't have any solution to give you now. Just to say that it's something that is on its way, and that it's not an easy one. On the citizen role, I think it's linked to a little bit what I touched upon about the governance in Europe. Is that based on what the European Commission is proposing, the competent DPAs that will take a decision that will apply to the citizen, for example, answer to a complaint, very simply, will be taken by another DPA, not necessarily his or her DPA. So if the company is established somewhere else, in Germany or in Ireland or in Luxembourg, it will be these DPAs that will take the decision for the French citizen. So we think that it's a pure violation of the European Convention, to be straight, and that it's just not possible to ask the citizen if he does not agree with the decision of the DPA to exercise his recourse in before the court of the DPA, so in another country. So if, for example, let's take an example, you don't like the decision that has been taken by another DPA, you will, for example, in Germany, you will have to contest and to exercise your rights in Germany with the German procedure, with the cost also of the German procedure. So we think that it's not possible. And that turns to your question. So we need to have also effective protection for the citizen. It's important that the citizen can go to its DPA, and that the DPA is responsible from A to Z on his complaint and its problem, and that if he doesn't agree with the decision of his DPA, he will have the possibility to attack his DPA on the French territory. So that's something that we are battling a lot against. And at an international point of view, which is the case with also big operators, where we need also to have a solution, an effective solution for citizens. That's what we are trying to achieve as well with the international conference, by creating a real network where we can exchange information and get back to the person with the right information very fast. But that's not something that is easy to do right now. I mean, you need to create, like, for example, a platform where you exchange information. So you need some IT system in order to exchange information. You need to also have common forms in order to have the right information. So it's something that takes time. Last thing also about the citizen. I don't know if you heard about that, but we are very much engaged in digital education at the CNIL. We are right now investing on, in fact, better awareness and to awareness campaign towards the citizen on the way they should protect their personal data. But it's bigger than that. It's also the way they should use IT technologies, and in order to feel better protected. And so that's a subject where the CNIL is very much involved. It's about to be more clear and more efficient towards our citizens.
Okay, just rapidly about, particularly about Prism, because that's a very sensitive topic internationally. the gentleman who asked the question said, what about Prism and all the other countries who are doing the same thing? I think that's an important point. The U.S. is under the spotlight for some NSA activities that may well have overstepped what is expected and appropriate in the U.S. Not to mention the law. I think President Obama has a privacy and civil liberties oversight board that is going to issue a report, I think, in the next few weeks. It may be delayed because of the strike and the budget thing. But the other countries at the same time, including France, it has come to light that the intelligence agencies live in a separate world, basically, and that they do operate in similar manners. And I would maybe in a bit of a provocative statement say that this debate is really one that should be dealt with by the legislature. It's a debate that has been, it is a very old debate. In the United States, we had the Watergate, wiretaps, which led to a law, I think, in the 70s that put a framework around wiretaps. In France, there was no law at all before 1991. The European Court of Human Rights condemned France for having no law at all. So, there's no framework for wiretaps, and yet there were many. In France, there was a parliamentary report just last March 2013 about the current French law in 1991 has many very large gaps that the intelligence agencies use with no supervision. U.S. has defects that are being looked at, but I think that it's a balance of fundamental rights and values, each of which have a constitutional ranking. The right to security. I think even the French Conseil Constitutionnel said, without a right to security, other democratic rights can't exist. So that, the security can't kill other rights, of course. Then you have a dictatorship. But without security, you don't have freedom of expression. You don't have privacy. So it's a balance of rights, and the real place that needs to be debated is at the Parliament and at the Congress.
Just two things maybe. So I don't have the answer on how we can cope with the two paces, the legislation pace and then the business, not as usual, but business development, innovation pace. But definitely the right to try that I think exists actually is probably a good thing. So experiment, go step by step. This is a very, again, it's everything changes very quickly, so we need to find ways to be able to move things forward, probably in a step-by-step way. Also, awareness, I think, is very important. So when we speak about privacy, so I think that lots of consumers have a very good understanding of what privacy is, and they are really concerned about it. But at the very same time, they do stupid things about their online identity by giving away their private details to some sites and let those details be visible by anyone, so in social networks, for instance, because by default maybe the option is that everybody can see, so and they don't know about it, or maybe they don't care until something wrong happens. So I think that there is ease of use versus security dilemma for the consumers, and we have to help them to actually behave in the right way online so that they can protect their identity in the best way. Because actually there's a lot of concern for privacy, but the worst things that can happen today is not by some company stealing the privacy or giving away data about you, but it's just about the consumers not doing the right thing to protect their identity, I think.
Yes, I can immediately build on that as regards the Snowden case. I think this case and the discussion provoked two interesting developments. One is mistrust, and that's a good thing. I do not really like when people talk about trust in systems, because trust always means that you overstretch your knowledge bases. You act and you do not know all the facts you should have to act. That's trust. And so that people start thinking about the systems and about protecting and identity systems, protecting your real identity and things like that. I think that's a good thing that this discussion started. That's one development. The other one is that you might have heard a couple of days ago that the German Telekom introduced an idea that they want to route the traffic in a way that it is inner German traffic will stay in Germany. And I think right now it's about a quarter of the traffic, inner German traffic, that is routed through the US. And they want to create a system, it's not clear whether that's technically really possible, that it stays in the country. And that's an interesting thought as well, this kind of renationalization. I'm not sure whether that's really the solution, because the innovative potential of the internet very much relies on the international character, but nevertheless. And Brazil and Germany and other countries concerned about those things found themselves among some unusual allies like China and North Korea, and like that makes it a little suspicious when it comes to these kind of solutions. But nevertheless, I think that's an interesting development, at least thinking along those lines. Second point, as regards time and flexibility. I personally believe that the mentioning of co-regulation is already a part of the solution, because we think about co-regulation because we believe that the industry has some superior knowledge. They develop the things, and so they know the problems that might arise before there is a public debate. And so some advantages of co-regulation rest with the fact that the industry has some superior knowledge, earlier knowledge, and can come up with solutions that are sufficiently flexible. On the other hand, co-regulation provides, if it's designed in a proper way, some safeguards that you do not really make the fox run the hen house, or whatever the metaphor in France might be. We have a similar thing with other animals in Germany, so that's always a risk, a real risk, and you have to design the systems accordingly. Maybe just a footnote as regards co-regulation. It's very specific, but I think it's important to see the broader picture. You mentioned the FTC settlement thing, and at the same time we have on a European level a suggestion about the design of the new general data protection regulation with explicit mentioning of co-regulation, and a rather strong element of co-regulation. When you now ask American companies whether they really like this idea in Europe to have this kind of co-regulation, which has a self-regulatory element in it, then they are a little reluctant, and I ask why. And one reason for that is the American FTC settlement thing, because they run the risk that when on a European level they start negotiating in self-regulation, that the FTC says, you have said in Europe on a voluntary basis that you want to have these rules apply, and then you did not follow the standard, and now we come down to you on that. And so it's not a self-regulatory element anymore. And so I think there is a need for a very elaborated system in between governments and legislators to see that you create the right incentives for the industry. On the one hand, you say with the FTC, a good cause, of course, we want to incorporate self-regulation, but in Europe it might have an adverse effect that companies do not enter into self-regulation. I think it's an extremely interesting development you can see here. Maybe just this thought.
Perhaps something about the role of the citizen and its education. The CNIL has a specific direction of a specific person who is in charge of the education of the citizen. But it's true that in France, at least, perhaps at the European level, the citizen doesn't react when there is a scandal, for example, Prism. I was also very surprised that there were no reaction about how draft law about identity card. The French Conseil constitutionnel censor, it's the English word, censor the draft law, and this law provided for a huge bases with all the French citizens and with biometric data, and there was no reaction. Just a little news at 8 o'clock at the TV, and that's all. So here, the French Conseil constitutionnel censures this draft law, and so we have a democratic mechanism. But I'm not sure it's sufficient. I think the citizen has to play a real role, and we don't have a strong association of citizens in Europe. And I think it's not the same in the United States, Winston. And also, perhaps one answer is class action. We don't have class action in France. It's a US mechanism. And I think it could be a good idea if we can have some class action.
Thank you very much. Is there any points regarding the question on Asia? Is someone would like to answer to Mr. who had the question regarding Asia? No? Your question was like regarding Asia, sir? Yeah.
No, it was about governance being too late.
Yes. Okay.
We tried to address that, but it's...
I just reinforce what Claire said, that the one particularity of the U.S. system is it's true there are some fairly powerful and vocal citizen civil rights groups historically in the U.S. The ACLU, for example, the EPIC, EFF. There are different groups that do have a real role in the public debate, and I think that whenever you talk about multi-stakeholder solutions, it's important to have some associations that reflect that negotiating point of view, because otherwise the citizens' view is pretty diffuse, and it's hard to put them at the table.
Just to complete on that, in the draft regulation there is something about the collective action, so it should change hopefully, and and also there has been a complaint on Prism, on the US Prism file with the French court. So there is now a complaint, at least, that will mean hopefully to a case law.
Yeah. Hélène.
I was just provoked to make a comment. Following what Winston said, because we do believe this, that the NGOs are watching out for the individual citizens, but I keep thinking to myself, isn't that what government is supposed to do? Isn't that what your legislatures, don't you vote them to represent you? So what happened to us? And I don't know about France. Maybe the French people have greater confidence in their government to reflect their individual rights, so that they don't think they need the NGOs. Anyway, can I ask? I have just a quick question that actually relates maybe mostly to some... I think this was a fantastic panel, by the way. Thank you so much. I learned so much. But this question about data protection versus privacy, well, not versus. You're saying... And so that's actually my question, is whether it's possible to say briefly what is that relationship between those two. And I think the autonomy issue may have...
Thanks a lot. Donc, regarding the first set of questions.
I'm sorry. Jumping on your first points. And it's going back also to what Winston said about co-regulation, self-regulation. It's true that I think because we have a legislation quite descriptive and that goes quite far in terms of rights, it's true that there is a kind of confidence of the citizen that what we call the controllers will comply with the law, which is not necessarily the case in the US, where there are maybe not the same general framework on on protection of privacy. Just going back to, but it's linked to what Winston said about co-regulation and self-regulation. It's true that we had a lot of debates about this accountability concept. Either it was self-regulation or co-regulation. And it's interesting to see that in the US, if you don't do anything, in fact, you are in a safer position than if you do something. Because if you do something, the FTC can do something against you by saying you have said that, as you said, yeah, you have said that you will do that. You haven't done it, so I punish you because you have not done what you have said. But if you don't do anything, and if you don't have any legislation, you cannot, do something against the company. At the CNIL, what we like very much about the draft regulation is that there is some accountability. So there is something about self-regulation, but it's framed by the regulators in terms of referential, so defining the standard of accountability, and also that it's becoming in fact a kind of obligation. So it's not anymore self-regulation. And if you don't do it, you get sanctioned for that. And it was very interesting to see this debate that is purely, it's also a problem of cultural approach, where we don't have the same view on this accountability, because in the US it's about self-regulation that will be sanctioned only if the company is doing something, and in Europe it's becoming in fact an obligation, co-regulated by the legislator and the DPA, because it defines exactly the standard. So it's true that it will not, when we are talking about conventions and the way we should frame that at a global level, it's very interesting to see that we don't have exactly the same definition of accountability.
Oui. 2 seconds for the right of privacy and the right of data protection. No, I can't. Sorry. So, in 2 seconds, the right to privacy is the right to have a private sphere, an intimate sphere, and this intimate sphere is protected, and you can act as you want in this intimate sphere. Do you agree with me? So you can have a sexual relation and so on in this intimate sphere. Okay. The second right, the right to privacy, is a more preventive right. That is, before someone enters in this private sphere, you have a right, you have a limitation principle as to the personal data. So the controller cannot do what he wants with the data, and the individuals have a right of to control what is done with his or her personal data, and a right to self-determination under German law also. So when you do that with the right to data protection, you also protect the right to privacy, and also other rights like right of freedom, right of non-discrimination, and so on. Do you agree?
Yes, to a great extent. I would say that it's, as I said before, as for me, it's about autonomy. And when you talk about data protection and talk about privacy, it's a different type of risk for autonomy. And one is the risk that there are data out there and somebody could recombine it in a way that affects my autonomy somehow. And when it comes to privacy, it's about my control over the sphere somebody else can intrude this to this extent or that extent. That I would say is the core there. And just a brief remark as regards the NGO thing. I completely share your doubts and say that government and parliament should be paramount and should reflect what the citizens' interests are. But in fact, as I said before, I believe when it comes to international standards on surveillance and things like that, we have failure of this kind of system. And so I personally believe without NGO power and without academics doing some part of the job, we will never have a kind of agreement restricting that on an international level. I'm quite sure.
Thank you very much for playing the debate. Thank you very much. Excellent presentation and debate. Thanks you.